Hi students, today we're going to talk specifically about the memo and the parts of the memo and trying to distinguish between CREAC in the memo, the conclusion, the rule explanation, the rule application, and the conclusion. So I'm going to share my screen. Some of these images on the PowerPoint may look a little bit familiar to you because I've used them before, but most of the content is going to be new. So as we may recall, legal writing is very different because it's based on the whole deductive reasoning model, where you have to start with your conclusion and justify it, which is why CREAC fits so well, right? Because you start with your conclusion and your goal is to validate or support that conclusion. Good legal writing is focused on the reader. It's not about making things easier for yourself as the writer, but making sure the reader is having an easy time getting through your analysis. Legal readers need context. It's so much easier to understand information when you know the relevance of the context, which is why CREAC works so well. Now, a legal memo has a standard format. Now, we touched on this before in class, but I wanted to touch on it again. In terms of the parts of a memo, you have your heading, which would be the to, the from, the re or regarding line, and the date. A section called question presented. Some people call it issue presented, doesn't matter. A section called brief answer. A section called statement of facts. The discussion section, some people refer to this as the analysis, and then the conclusion section, which gets its very own heading. Notice I put discussion in larger font. That's because that's the most important part of the memo for our purposes as attorneys. This is where the law, the legal rules, the analysis is contained. It's the lawyering part. It's also where you will make your prediction. So I wanted to go through a few sample memos with you guys today. But first, let's just go through the basic template. In the discussion section of the memo, you should have as one of the first paragraphs, the overview paragraph. That's where you're going to, again, talk about your conclusion, the elements that make up the cause of action, which elements are not in dispute and which elements are in dispute. That overview paragraph, you can think of it as sections too, because it can be sections because remember, your thesis paragraph deals with microorganization. Now that you've identified the element or elements in dispute, your thesis paragraph will take one element at a time, state your conclusion about that element, and how is that element satisfied? What factors does the court consider? All that would be in your thesis paragraph, followed by your rule explanation, where you're talking about precedent, the facts, holding, and reasoning of precedent. Your rule explanation is an opportunity for you to give an example of how the law has applied in the past. You've summarized how the law has applied in the past in your thesis paragraph. This is your time to really support what you've said. Your analysis is where you put it all together by analogical reasoning, comparing distinguishing cases, considering counter arguments. And then you would restate your conclusion and maybe a sentence or two before you do it all over again in your thesis paragraph. So let's just pause for a second. So if I can get my, as I show you another document that I think will help you if we go through it. Sometimes all my screens get confused. There we go. So this particular document that I'm showing you is from a textbook that I tend to use in my classes. Let's see if I can make it bigger. There we go. I haven't decided yet if I'm going to use it again for this semester, but one of the best parts about this textbook is what I'm showing you right now. It's Appendix A in the book, and it gives you a sample memo. What's really unique about the sample memo is it has all of the parts of the memo annotated in the margin. So notice, as we said earlier, that you have your heading here, followed by your question presented. And here it tells you what you should look for in a question presented, your brief or short answer, and it gives you some information here, your statement of facts. For our purposes, we're going to focus on the discussion section. And notice the discussion section, the very first paragraph should be your overview paragraph. And here it's telling you that this is your overview paragraph. And like most good overview paragraphs, it starts with a conclusion, the rule of law or the elements, dispenses with non-issues, and identifies the issues in dispute. Let's see how it did. The Stripes Garage is a dwelling under Illinois residential burglary statute. Right off the bat, I know the conclusion. To prosecute Arnold successfully under the statute, the state must prove that Arnold knowingly and without authority entered the dwelling place of another. Gives the statute. Great. There is no real dispute that Arnold knowingly entered the Stripes Garage or that his entry was without authority. All right, that's what's not in dispute. Whether the garage is a dwelling place is more problematic. That's the issue. The statute defines a dwelling as a house, apartment, mobile home, trailer, or other living quarters in which the owners or occupants actually reside. And then it does something that I hate, so please don't do this. This memorandum addresses. A better way to say that is the court will focus on or what have you, but don't get into what this memo will address. I think that sounds sophomoric. Whether the Stripes Garage is a living quarters in which Michael Stripe actually resides is the primary dispute. That would have been a good way to do it. So this sample serves as a really good checklist for you. Let's see how they do the thesis paragraph. Notice the next paragraph is the thesis paragraph, and it reminds you that you should start with your conclusion, identify the relevant factors, and the synthesized rule. The Stripes Garage is a living quarters in which Michael Stripe actually resides. There's your conclusion again. When determining whether a structure is a living quarters, courts evaluate the type of activities for which the owners use the structure, as well as the frequency of those activities and physical evidence of those activities. Those are the factors, even though they didn't say, or did they? No, they didn't say the factors the court considers. I can tell just by the way that it's written, these are the things that the court considers to determine if it's satisfied, which is the definition of factors. And next reads, a structure is considered a dwelling when the owners frequently use the structure for activities that occur in the living quarters and the furnishings reflect that use. Although a structure's attachment to the main residence is also relevant, physical attachment to the primary residence is not necessary. Therefore, a structure used as an extension of the home's living quarters may be a dwelling, even though it is not physically connected to the primary residence. Because Michael Stripe frequently and regularly uses the Stripes Garage as living quarters, it satisfies the statutory definition of dwelling. Okay. So there we have our thesis paragraph. As I told you before, it's followed by the rule explanation, rule application. Now, we're going to talk about the rule explanation and rule application later on in class. Right now, I really just want to make sure I highlight roadmaps to you guys. The second example is from a former student. This was their very first writing assignment. And I like to go over it because it also goes through the things that we've went through before. You've got your heading information, followed by your question presented and brief answer, statement of facts, and then you start with your discussion. And right off the bat with the very first sentence, I'm expecting the C of CREAC. I do not want to see a sentence that says the issue in this case is. That is not a conclusion. I want you to state your conclusion. Notice how this writer started out. The state will be able to prove a prima facie case of operating a motor vehicle under the influence. Right off the bat, it lets you know the state's going to win its case. Then it quotes the relevant statutory language. After that, it still lets the reader know you've got to prove three main elements: first, second, and third. In this case, now they're talking about the second element is not contentious. It is trying to get rid of those non-issues, those issues that are non-dispute. And then it's telling you what's in dispute. The first issue is whether she was in actual physical control. The second is if she was impaired since her breath alcohol was less than 0.08. I'm going to give you some additional instructions later on our Canvas website, but I would like you guys to annotate this sample memo in a similar way that Appendix A is annotated. In other words, once you get to the discussion section, What parts of CREAC should be highlighted in this section? Well, I'll tell you right now, it's the C and the R of CREAC. What section is this called? Is this a thesis paragraph or the rule explanation? Well, you should know by now, this is the overview paragraph. And what about the next paragraph and the paragraph after that? So take some time to label out this memo and we will discuss it in class. All right. So that's all I have for now, just to give you guys accustomed to the memo and set up for a slightly larger assignment where I'm going to give you 2 final memos. One student did very well and one student did very poorly. And I'd like your insight in terms of what's the difference between the two. Enjoy the rest of your day.